thousand, turn us to thousands, and we'll grow in number, fueled by them to see the horizon, turn us to thousands, and on we'll go, through the wastelands, through the highways, till my shadow turns to sun rays, and on we'll go, through the wastelands, through the highways, and on we'll go.
Assalamualaikum and selamat Hari Raya Rifa.
Oh, thank you. You too. So, what's up?
Sorry, not meant to break your Raya mood, but I have some bad news.
Hey, don't scare me like that. What is it?
Have you received the mail from Yayasan Usahawan Niaga?
No, I haven't.
Okay, ya Allah. Yayasan sued us for failing to pay back the loan that our company made 3 years back.
Eh? Why us?
I know, right? We are not the one who's supposed to responsible for this.
And then, what should we do?
It's okay. I have my personal lawyer. I will discuss with her and then I contact you later, okay? Bye. Hi miss, I'm pretty sure that you have read my mail. So basically the problem is Yayasan tried to sue 2 members of my company, including me, because my company A&A Sendirian Berhad failed to make repayment of loan made to Yayasan amounting 50,000 ringgit that should have been paid within 3 years period given. And I'm sure that a company is an artificial legal person created by law. So company and the members of the company is separate legal entity, right?
That's true. It is stated in the Section 2 of Companies Act 2016 that defines a company. By the virtue of Section 20 and 21, it stated that a company will acquire a legal personality as well as a legal capacity as a competent person. So when a company is formed and registered, the company will become a separate legal entity, which means the company and its members are 2 separate bodies. We can refer to the case of Salomon and Salomon Company Limited, where Salomon ran a shoe and boot business as a sole proprietor. He later incorporated a company, Salomon and Corporate Limited. During liquidation, the company's asset was not sufficient enough to repay all the company's creditors. As a debenture holder, Salomon ranked in priority over the company's unsecured creditors, so he managed to get a portion of his debt back. The liquidator brought an action to prevent Salomon from receiving any payment, as he claimed that Salomon and the company was essentially the same person. But the court held that once a company is incorporated, it becomes distinct from its members, even though Salomon managed the company by himself. So, Salman can advance the money to the company and was entitled to be paid as a creditor. In the same section, it also explains that a company can sue and be sued. A company is liable for all action undertaken under its name, whether in contract, promissory note, or other document. The liability is not the member's liability, so a third party cannot take action on any members of the company. The members of the company also cannot take any legal action on behalf of the company.
I know the case related to this one, but I don't really remember the name of the case. But it's about a directors of a company. They misapply the company's property, and then the two shareholders of the company take a legal action against them on behalf of the company. But court rejected the suit made by the shareholder, because the shareholder is not a proper plaintiff, as they don't have what they call a locus standi, or they don't have right to bring the case. Okay. The company is the one that suffered the injury, so only the company can take legal action as they are the proper plaintiff.
Yes, that is the case of force and arbiter. Other than that, liabilities of members are limited. As a company is a body separate from its members, the company is liable for its own liabilities and not the members. Therefore, the member cannot be sued personally for the liabilities of the company. In other words, we can say that the members are protected and their personal property or money cannot be taken to settle the company's liability. Okay, so as the firm is defined as a company in Section 2 that I've stated before, it will bear all the effects of incorporation as in Section 20 and 21. So you and your other member cannot be sued for the non-payment of your company to Yayasan Usahawan Niaga because A&A Sendirian Berhad is a body corporate whereby it enjoys a separate entity and does not depend on the identity of its members. A company is liable for all actions undertaken under its name, and in your case here, your company is the one who failed to make the repayment to Yayasan, so the liability of it is not on you.
Thus, Yayasan cannot sue me and Arifah, right?
Yes, that is true. So in conclusion here, the liability of the non-payment of the 50,000 loan is on A&A Sendirian Berhad, and Yayasan Usahawan Niaga cannot sue you. So you don't have to worry. I hope that helps.
Oh, ya Allah. Thank you so much, Miss.
Hello Lawyer Hafiz, how have you been? Sorry for disturbing you during this MCO. I just want to settle this matter with you.
Oh, hello Jannah. I had a great day doing work in my home during this MCO. What's the matter?
Atika has issued a check to me worth 5,000 ringgit on behalf of her company without stating the company's name into it. May I ask whether the check is void or valid? And if it's void, may I sue Atika which making her liable for the payment made? Before this, I had studied that a company is an artificial legal person created by the law. Once it is incorporated, it comes into being and is a separate legal entity from its member.
Virtue Section 2 of the Companies Act 2016, a company incorporated under any corresponding written law process where a company acquires a legal personality in the eyes of law and becomes an artificial person is called incorporated. When the company being registered, it must have some characteristic, guideline or effect of incorporation. One of them, liabilities of member are limited. According to Section 192, Subsection 1, Companies Act 2016 provides that a member shall not be liable for an obligation of a company by reason only of being a member of the company. Liability of a member of a company is limited. D. Any liabilities as provided for under this Act.
So from the characteristic that you mentioned just now, the company is separate from its member. Thus, it follows the liabilities of the company and the members should also be separated. Therefore, the members cannot be made liable for any act carried out under the company's name or involving the company's property or business.
Furthermore, even if the company has no asset left, creditors cannot sue members of a company because they are not responsible for its debt. By the same token, a company cannot be made liable for the personal liability of a member.
Oh, how can we conclude this?
The check that Atika had issued is void because it does not have any company name on it, and we can conclude that Atika settled the debt of the company by using her own account. Therefore, Atika is not liable or responsible for the debt to Jannah amounted to RM 5,000 ringgit Malaysia because it is the liabilities of the company. Thus, the company is separate from its members.
But in my other perspective, I can see that Atika carries the business with the intention to defraud her company's creditor, which means me, that being her, intentionally did not state her company's name in the check. And in my knowledge, it falls under fraudulent trading, which occurs when an officer of the company carries on any business of the company with intent to defraud the company's creditors. This is by virtue Section 5040, Clause 1, Companies Act 2016 provides that the official personally liable for all or any debts or other liabilities of the company. This happened when the court lifting the corporate bill of incorporation, which the matter falls under exception provided by statutes or common law, using this to the doctrine of separate legal entity.
We can see in the case of Huatah Sdn Bhd and Yap Chi Kian and others, Huatah obtained a judgment against Billions Showcase Sdn Bhd BSSB, but the judgment debt was never paid. Instead, BSSB was wound up. Huatah then sought a declaration from High Court asking for the directors of BSSB to personally pay the judgment debt. Ordinarily, BSSB would be separate legal entity from its directors who cannot be held personally liable. However, exception apply if the directors have been guilty of fraudulent trading.
So, how can we settle and conclude this case from your knowledge and perspective?
The check is void on the first place because Atika carries on a business of the company with the intent to defraud the company creditors, which proven with her action that did not stating the company name onto the check. If Atika no intention to defraud, she is using her own account to pay the company debt. She is not to be made liable on it because companies and members is separate legal entity. Furthermore, by using the second law, which is fraudulent trading, the check will also be void, but Atika must take responsible for it because when the court had lifting the corporate bill, the company and members are no longer separate entity.
It is a great opportunity to hear it from you. Thank you very much. See you soon.
You are welcome and see you soon. Don't forget to stay home and stay safe.